Welcome back, everybody, to a lovely Canadian wildfire smoke-filled evening out here on the dock. Today we actually have some good news for you, so I like to bring those videos to you. Lately, it's been a lot of bad ones, but we have some good stuff today going on, and it comes out of the Fifth Circuit Court. It broke last night, late last night, so we're going to do a video for you today. I read the entire ruling as it pertains to frames and receivers and the ATF trying to regulate them as firearms. The entire ruling is like 38 pages. I will leave a link to it down below in the video description if you guys want to check it out. I'm going to kind of hit some highlights here in this video, and then I'm going to talk about why it is so significant. So for those of you guys who haven't been following along, in the past, I guess, 2 years total, the ATF has been trying to change the definition of a firearm to include mostly what they were targeting was like 80% firearms or ghost guns. That's liberal terminology, and it doesn't actually have a legal definition, if you will. So something like this. Something like this is a polymer frame that you could do some milling to, and then you could, at home, with, again, some work, some jigs, some things like that, you could turn it into an actual functioning firearm. And of course, it's not serialized. Now, again, for the new folks here, you have always, since before America was a country, since before 1791, you have always been able to make a firearm and keep it legally as long as it's not for sale in America. That's always been the case. It's never not been the case. And essentially the ATF was trying to say that you couldn't do that. And the way they tried to word it with their final rule on braces and, on frames and receivers was that pretty much anything could be a firearm, according to them. And if this final rule was allowed to go forward, there was a lot of concern, valid concern in my opinion, that certain things like, say, an AR-15, that your AR-15 upper receiver could be considered a firearm, things like that. So the FPC, Firearms Policy Coalition, went to work, got their lawsuit going, and it has been ruled on by a judge and done so in a very good way, with the language indicating some things that are probably going to come in the next month or so. At least that's my opinion anyway. So I'm just going to read the introduction, and then I'm going to read a key phrase at the end where the judge is beating them up, the ATF that is, and I think it's going to foreshadow something that's coming in the future. So, introduction. This case presents the question of whether federal government may lawfully regulate partially manufactured firearm components, related firearm products, and other tools and materials in keeping with the Gun Control Act of 1968. Because the court concludes that the government cannot regulate those items without violating federal law, the court holds that the government's recently enacted final rule definition of frame or receiver and identification of firearms is unlawful agency action taken in excess of the ATF's statutory jurisdiction. On this basis, court vacates the final rule. So there you go. The final rule is thrown out, and the ATF cannot regulate how firearms components are sold. So in the immediate future, I'm guessing on Monday, companies like 80% Arms, Polymer 80, etc. will start to sell their frames with jigs again. So this has gone back and forth again over the past couple of years. Basically, the ATF said at one time that you couldn't sell something like this if it had a jig with it. You couldn't have it on the same order if you ordered it online at, say, Brownells or something like that. But I'm guessing on Monday that is all going to change. Additionally, there are a number of state lawsuits against these companies that are making 80% type items, AR-15 lowers, Glock lowers, 1911 frames, etc. So I think a lot of that is going to change here in the very near future due to this ruling, because obviously it sets precedent for the entire United States. Now, speaking of setting precedents, I'm going to get to another part of this ruling, and it's 38 pages. If you guys actually want to read it, the judge does a really good job of beating up the ATF on all types of levels. So it's fun to read because you guys will just see the ATF get roasted in their attorneys. But the judge says, in sum, the Gun Control Act's precise wording demands precise application. Now, let me back up here for folks who are unfamiliar with the Gun Control Act, new folks. Here, Gun Control Act is where the federal definition of what a firearm actually is legally accepted. It was actually passed by Congress. It was signed by the president. It is an actual law, unlike the ATF's final rule here. It goes on to say, Congress could have described a firearm as any combination of parts that would produce a weapon that could fire a projectile. It used that language elsewhere in the definition. Congress could have described a firearm as any part designed to be part of a weapon. It used that language too i.e. elsewhere in the legislation. Congress could have described a firearm as a set of parts that may be readily assembled into a weapon as it did for a destructive device. Congress could have written all those things, and the very definition of a firearm demonstrates that Congress knew the words would accomplish those ends. But Congress did not regulate firearm parts as such, let alone aggregations of these parts that are designed to or may readily be completed, assembled, restored, or otherwise converted to expel a projectile by the action of an explosive. Accordingly, the final rule's attempt to regulate weapons parts kits lacks statutory support. So what he's going on there in detail, and again, he goes into it based on the history, text, and tradition of the United States, based on the recent Supreme Court Bruin decision. And what he's getting into there is the ATF cannot redefine what something is. If it's not a firearm, it's not a firearm. If it is a firearm, it is a firearm. So this is the Fifth Circuit Court. So as of the 29th, so a couple days ago, as when I'm recording this, the Firearms Policy Coalition is also going before this very same court, this very same group of judges, to argue that the ATF's pistol brace rule or pistol brace redefinition is unconstitutional and should be thrown out because the ATF doesn't have the statutory authority to change the definition of what a SBR is, what a destructive device is, what a short barrel shotgun is, and what a brace is or a stock is. They do not have that authority. So going forward, it looks very good that the Fifth Circuit will likely, of course, come to the same conclusion when it comes to braces. Now, of course, I do not know that. I have no way of knowing that. But based on what we read here, if you guys actually read the whole thing and you guys realize that it's the same court system that is going to be ruling on that, it looks good for us. How long will that take? I have no idea. So speaking of that, make sure you guys are subscribed, because when that breaks, we will bring it to you here on the channel as well. And with that, we will end the video. Thank you all for watching. I truly appreciate it. If you guys aren't subscribed, again, make sure you hit that subscribe button. If you are subscribed and you're not seeing 2 to 4 videos a week here on the channel, make sure you sign up for my email at the website here on your screen. This email goes out once a month, and it has all the videos since the previous month's email. Additionally, if there are daily deals, whether it be on frames or receivers, ammo, optics, guns, etc., that will go out in my daily deals email. You can sign up for that at the website here on your screen. There's also usually a pretty solid meme in there that the audience does seem to like. And with that, we'll close it out. This one's a win, but more fights to go.